Thursday, August 1st, Robert Krajcik reporting for Rebel News here in Lethbridge, Alberta, at the trial of Chris Carbert and Anthony Olenek. Yesterday, the jurors received their instructions, the charge from the judge, Justice David Lebranz, before being sequestered and retiring to deliberate their verdicts in the charges against the defendants. Both Chris Carbert and Anthony Olenek are charged with conspiracy to murder. The Crown is accusing the two men of conspiring to murder police officers during their time at the 2022 Coutts protest and blockade. The two defendants are also charged with unlawful possession of a firearm for a dangerous purpose and mischief over $5,000. Anthony Olenek is additionally charged with unlawful possession of an explosive device for a dangerous purpose. Now, the 2022 Coutts protest and blockade, much like its sister demonstration in Ottawa, Ontario, the Freedom Convoy, was a peaceful and civilly disobedient demonstration against what I have dubbed the COVID-19 enterprise, this governmental apparatus of surveillance and control and censorship, all levels of government issuing edicts and orders and mandates, ostensibly in the interest of public health, to reduce COVID-19 transmission. Rebel News is really the only news media outlet that can claim that we've been covering this story since day one in a deep way. We had journalists and reporters at the site at Coutts in 2022 reporting on those events and producing unparalleled journalism. Now, fast forward to here, Lethbridge, Alberta, beginning of August 2024, we're still deeply invested in reporting on these trials that have flowed from prosecutions coming from this demonstration. And of course, we have operational costs. I don't work for free. And the way we maintain this journalistic enterprise is through our beautiful and benevolent audience. So folks, contribute, donate, help us out so we can keep this thing going. Visit truckertrials.com and stay up to date with our ongoing coverage. Yesterday was a very long day of proceedings. We began late, around 11:30 in the morning Mountain Time, as opposed to the usual start time of 10 in the morning, and they ran all the way until 6 in the evening. The reason for the delay in the morning was that at that time there were still some unresolved disputes between the Crown and defense teams with respect to language they sought to have included in the judge's instructions that he provided the jury. And those instructions took a very long time to deliver. And the instructions amount to basic directives and guidelines regarding jurisprudential principles, basically how to interpret evidence, how to understand the nature of the specific charges. Of course, the judge is not telling jurors what verdicts to render in the charges against the defendants, but just how to interpret things in terms of legal principles. Right out the gate, the judge emphasized what he described as the most important jurisprudential principle, the principle of justice, that being the presumption of innocence that is placed upon the defendants. The burden of proof lies entirely upon the Crown, and in order to secure guilty convictions on any of the charges against either defendant, the Crown must prove in the minds of the jurors beyond a reasonable doubt that those crimes were committed. The other side of that reasonable doubt, of course, is the benefit of the doubt, which is to be extended to the defendants. The judge emphasized that the defendants do not need to prove anything. They don't need to prove their innocence. The judge explained to jurors two essential elements of the charge of conspiracy to murder. And these two essential elements must be proven beyond a reasonable doubt in the minds of the jurors by the Crown in order to render a guilty verdict on this charge. Keep in mind that these two essential elements must also be proven by the Crown in any charge to any defendant who is accused of having committed a conspiracy towards some unlawful act. Now, element number one. It must be proven beyond a reasonable doubt, it must be demonstrated to jurors that the alleged co-conspirators actually agreed to conspire to commit an unlawful act. As the judge put it, it must be demonstrated that amongst the co-conspirators, there was a meeting of the minds towards commission of that illegal act. And that agreement may be demonstrated in the form of speech or speaking or some sort of gestures between the co-conspirators. Element number two, it must be proven beyond a reasonable doubt that the alleged co-conspirators engaged in furtherance of that conspiracy. Furtherance refers to specific actions that were undertaken by the alleged co-conspirators towards execution of this illegal act. So in a simple example, imagine two co-conspirators actually conspire to rob some store. It must be demonstrated that one or both of them were casing the store, casing the business, examining it, trying to see when it was that the business owners or employees left. It must be demonstrated that, for example, they made copies of keys to enter that business when the business was unattended. So it must be proven beyond a reasonable doubt that co-conspirators who are accused of having conspired to commit a crime actually took action towards the commission of that unlawful act. The judge told jurors that he was there to, quote, help you make a decision, not to tell you what decision to make. He also stated that he would explain the possible verdicts that they could render, and also that in order for either guilty or not guilty verdicts to be rendered on any of the charges, there must be unanimity among all the jurors. The judge explained to jurors that if he makes a mistake in his capacity as a judge, that there is a potential corrective remedy. There's a way to fix his potential mistake, given that all of his conduct is on the record and subject to an appeal. The jurors' deliberations, however, are in secret and are therefore not fixable if they make a mistake, whatever that might mean. The judge advised the jurors to listen attentively to other jurors, that they must maintain rationality amongst themselves, to behave rationally, to stay calm and reasonable in terms of their deliberations between themselves. Lebrun's repeatedly invited jurors to use good common sense in terms of their deliberations and decisions. He advised them to not be emotional, to maintain rationality, and to be reasonable in terms of their deliberations. The judge also proceeded to provide a pretty lengthy summary of evidence as it was presented, but he also told jurors that they are under no obligation to take his summary seriously. They don't need to focus on what he focused on, that they are entirely independent as the triers of fact to determine guilt or lack thereof in their own capacities in fulfilling their civic duties. Justice David Lebrun reminded jurors that Chris Carbert took the stand as a witness in his own trial. He advised jurors that they must treat Chris Carbert like they would any other witness in terms of their determinations of his credibility or reliability, their perception of his earnestness or lack thereof. On the other hand, Anthony Olenek did not testify in his own trial, and the judge advised jurors not to make any inference based on that. He stated that they cannot use Anthony Olenek's silence at trial as evidence of his guilt. The judge also reminded jurors that anything any lawyer says is not evidence. So any words out of the mouths of the prosecution team or out of the two defense attorneys is not evidence. He also said that about himself, that his statements are not evidence, and jurors are welcome to disregard his analyses in many ways, but not his legal directives in terms of how to understand charges and how to proceed with certain legal details about their deliberations. Forgive the teaser, but recall that there have been a lot of proceedings in this trial subject to a publication ban. Both after the jury's impanelment, meaning after the jury was selected, a lot of proceedings took place in their absence as the competing parties disputed certain aspects of the trial. There was also a lengthy period of proceedings in pretrial before the jury was selected. That was also subject to a publication ban. Note that I use the word was, it's past tense. All of the publication bans have now expired given that the jury has retired and is sequestered in doing its deliberations. So while I cannot go into all the interesting things that occurred in these proceedings that were subject to a publication ban, I will do that in the immediate future. And you folks will get insight into all of these interesting developments that I was unable to report on until now. The judge also explained the standard of proving something beyond a reasonable doubt and said that that standard is met even if there are these remote possible alternative explanations in the minds of jurors. In other words, if something is possible but remotely possible, that doesn't make it reasonably possible. He also said that beyond a reasonable doubt is near the standard of absolute certainty, although absolute certainty is an unattainable standard for most things in life. The judge also told jurors that they must not engage in propensity reasoning. They cannot make inferences of their perceptions of the likelihood of the defendants committing the crimes they're alleged to have committed based on their assessments of the characters of the defendants. In other words, they cannot make inferences of guilt or lack thereof on the part of the defendants based on how they interpret the defendants' characters. He specifically mentioned ideology in politics. So, for example, imagine jurors have an agreement or disagreement with the defendant's politics or ideologies as they perceive them. They cannot use that in terms of determining guilt or lack thereof. The judge also told jurors they must not use either sympathy or prejudice in the rendering of their verdicts. They can't use this sort of emotional calculation in terms of their determinations of guilt or lack thereof. The jury is inside the courthouse right now doing their deliberations. The judge has given them until about 8:30 in the evening, which means if they don't reach a decision by that point, they're then going to retire for the evening, go to their accommodation, relax, recharge, and then resume their deliberations the following morning. Of course, I'm on sort of call, and I'll be here ASAP if I get word of some verdict coming in or some other development, which might be something like a question from the jury. Rebel News had reporters embedded on location at the 2022 Coutts protest and blockade, producing unparalleled journalism. Hopefully, I'm still able to carry that torch forward into today, 2024, where we're reporting on trials flowing from prosecutions that came from that demonstration. There's no other news media outlet that can claim that deep connection to these events as they unfold. And unlike our so-called mainstream news media competitors, we're not getting handouts from the federal government to toe that official line. We depend on our beautiful audience to donate and contribute to our operational costs. So please do so. Visit truckertrial.com so we can keep this journalistic enterprise going and stay up to date with our ongoing coverage.